Good morning, afternoon, or evening, as the case may be. My name is, just a minute, I have it here, William Huber, except I use Dennis because some bad people are looking for me and I have to confuse them. This video is copyright 2020 by William Dennis Huber, recorded exclusively for the use in Professor Richard Kravitz's LLM courses in ethical decision making and fiduciary responsibility and risk management at Texas A&M Law School. Unauthorized reproduction is prohibited. Professor Kravitz asked me to make a 5-minute video with 5 takeaways from my book, Volume 1, Corporate Law and the Theory of the Firm, Reconstructing Corporations, Shareholders, Directors, Owners, and Investors. If you order now, we'll be happy to send you another book at full price. All you have to do is call the number at the bottom of the screen. Operators are standing by. We don't have operators. There is no number at the bottom of the screen. Okay, well, we'll work out something. 5 takeaways in 5 minutes. That's 1 minute per takeaway, except now it's less because I've had to take time explaining to you that it's 1 minute per takeaway. Okay, throughout the video, I will ask you some questions. Some of the questions I expect everyone will answer incorrectly. Many questions I expect everyone to answer incorrectly unless you've already read my book. I expect that you will answer them according to the way you've already been brainwashed into answering the questions. So let's get started. We'll start out with the accounting equation. I'm sure everyone here knows that the basic accounting equation is assets equals liabilities plus equity, or the European way, assets minus liabilities equals equity. And that's a very important consideration. So I'll ask you, according to property law, who owns the assets? The assets are the property, right? And it is without question, without debate, it is the corporation that owns all of its assets, all of its property. Who owes the liabilities? Who owes the debt? It is also without question that it is the corporation that owes the debt, owes the liabilities, responsible for the liabilities. So the corporation owns the gross total assets. Therefore, assets minus liabilities equals net assets, and therefore the corporation owns the net assets. But the net assets is simply the equity. Therefore, every single accounting textbook, paper, book is incorrect because it is not shareholders' equity, it is the corporation's equity. Shareholders do not own the equity, they do not own the property, they do not own the total assets, therefore they do not own the net assets. So what happens is expecto patronum, we turn something that the corporation owns into something that the shareholders own, something Dumbledore, Voldemort, and Grindelwald could not accomplish, but yet has been accomplished for several hundred years simply by the dictum of the court. So the first takeaway is shareholders do not own the equity. Shareholders have no claim at all on the corporation, its assets, its income, or its equity. Takeaway number 2, and by the way, these are not in any particular order. Trusts. You probably have seen judicial opinions ruling that directors are trustees of corporate property. So I will ask you, are directors trustees of, rather, shareholders' property? Are directors the trustees of shareholders' property? I expect everyone here will answer incorrectly, yes. The correct answer is no. What is required to establish a trust? The trustor, the trustee, and the beneficiary. The trustor transfers legal title to the trustee. The beneficiary has no title except as a beneficial owner. When a share owner purchases stock, does a share owner transfer property, i.e. cash, to the directors? No. The share owner transfers property, her cash, to the corporation. So how can trustees be directors? Or how can directors be trustees? They're not involved in the transaction at all. The transaction is the share owner purchases stock and in return receives a share of stock. The share owner has something in return. A trustor merely gives title to the trustee and receives nothing in return. A share owner receives something in return, a piece of paper that says share of stock. Okay, so directors cannot be trustees because trust law does not apply. If trust law does not apply, directors cannot be trustees. Therefore, the second takeaway, directors are not trustees, and therefore directors have no fiduciary duty to share owners as trustees. Third takeaway, agency law. What is required for agency law? There must be a principal who appoints or hires the agent, two parties, not like a trust. Okay? A principal hires the agent. An agent does not hire a principal. Yet what happens? When a corporation is formed, a corporation has directors with no shareholders. There must be directors, either listed in the certificate of incorporation or elected by the incorporators. Therefore, there are directors with no shareholders. If directors were agents, they would be agents of non-existent principals. Directors then issue shares, thus creating principals. That is not allowed under agency law. It's the principal who must hire the agent. Now, a major factor to consider here is who is liable for the acts of an agent? The principal. Are shareholders liable for acts of the directors? No. Who's liable for the acts of the directors? The corporation. Therefore, the third takeaway is directors are not agents of directors are not agents of share owners. They are agents of the corporation. Since they're not agents of share owners, they have no fiduciary duty to share owners. Takeaway number 4, owners of corporation. How many of you think that share owners own corporations? I expect all of you are going to answer incorrectly and say yes. That is not correct. Share owners do not own corporations. What do they own? They own a piece of paper that says share of stock. They do not own the corporation. From your property law class, you know that anyone who owns property can do anything with the property that they want to, with certain restrictions, zoning laws, don't use it to harm others, and so forth. Okay, that's not important. Can you, as a share owner, use the property of the corporation? Can you go in and use their machines, use their building? Of course not. That's because you don't own the corporation. You own the share of stock. The Delaware corporation law states that shares of stock are personal property. Okay. The Uniform Commercial Code states shares are financial assets. You, as an owner of a share of stock, do not own the corporation. You simply own a share of stock. So the fourth takeaway is share owners do not own corporations. That actually makes corporations dangerous because share owners don't own corporations. No one owns a corporation. Okay? Don't argue that in court, they'll toss you out, but that's true. They are not residual owners because share owners have no claim on any assets, income, or equity of the corporation. They have no legal claim at all. Bondholders have a claim for principal or interest. You, as a share owner, have no claim. You cannot be a beneficial owner because there's no trust. Okay? Takeaway number 5, investor. How many of you think that share owners invest in the corporation? Probably all of you. That is incorrect. You've been brainwashed. Share owners invest in pieces of paper, the stock, just as bond owners own bonds and invest in the bonds. You don't invest in the corporation. If you invested in a corporation, that would mean you have ownership rights in the corporation. A sole proprietor has ownership rights in his corporation. A partner has ownership rights in her partnership. You have no ownership rights in the corporation. You have a piece of paper with expectations that you might receive a dividend and the price might increase, and you can realize it when you sell the stock in the market. So that's the fifth takeaway. Share owners do not invest in corporations. That's your 5 takeaways. I see we've gone over 5 minutes. You will receive a surcharge on your tuition bill for the extra 5 minutes. But I'll give you a free 6th takeaway. When courts rule that share owners own the corporation, that directors are agents of trust or trustees of share owners, that they're investors in corporations, they do not know what they're talking about. They're merely repeating something that has been handed down for basically centuries. They are wrong. So with that, I will bid you adieu. By the way, Professor Kravitz will be happy to answer any questions you have. And if you wish to contact me, he's free to give out my email address. Thank you.